Hello, everyone. Welcome to the U.S. Immigration News. A lot of people watching this channel are waiting in a very tense part of the immigration process right now. Some are stuck in green card lines. Some are preparing an I-485 package and hoping nothing gets rejected over one small filing mistake. Some are watching the H-1B process and wondering whether the system they prepared for even looks the same anymore. And that is why this update matters so much, because from 2026 forward, USCIS is not just making small technical edits here and there. The agency is changing how cases are selected, how forms are accepted, how evidence is reviewed, how identity is verified, how payments are made, and how long many applicants may have to wait before they finally see movement. A lot of these changes began in 2025 and 2026, but they are the changes that will shape green card H-1B and I-485 cases well into the next couple of years. In this video, we are going to talk about 8 major USCIS changes that are now affecting green card cases, H-1B filings, I-485 adjustment cases, and the way many families and workers will experience U.S. immigration from 2026 onward. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. The first major change is on the H-1B side, and it is one of the biggest shifts we have seen in years. DHS finalized a weighted H-1B selection rule at the end of 2025, and that rule took effect for the FY 2027 CAP season in 2026. Instead of a system that treats registrations more evenly after the beneficiary rules were tightened, the new rule generally favors higher-skilled and higher-paid H-1B candidates. The Federal Register says the new system generally favors allocation of H-1B visas to higher-skilled and higher-paid workers, and it even estimates much lower selection odds for Level 1 wages than for Levels 2, 3, and IV. So for employers and workers, this is not a cosmetic adjustment. It changes strategy, it changes filing expectations, and it changes who is more likely to win the CAP race. The second big change is that the H-1B program itself has been rewritten in a more demanding way through the modernization rule that took effect in January 2025 and continues to shape adjudications. Now, DHS said that rule was meant to clarify requirements, improve efficiency, add some flexibilities, and strengthen integrity measures. But when you read deeper, you see what that means in practice. USCIS now has clearer authority to request contracts, demand proof of a real specialty occupation position, require the LCA to properly match the petition, and conduct site visits. The rule also makes clear that refusal to cooperate with site visits can lead to denial or revocation. That means H-1B cases, especially third-party placement cases, are now living under a much stricter compliance environment than many employers were used to before. The third change is procedural, but it is serious enough to destroy a case if people ignore it. USCIS published a new edition of Form I-129 on February 27, 2026, and said that beginning April 1, 2026, it would accept only the February 27, 26 edition. USCIS also said all H-1B CAP subject petitions for FY 2027 must use that edition. That means a lot of people who prepared cases using old templates, old attorney checklists, or older employer packet systems can run into rejection risk just because the wrong edition was sent. In immigration, that kind of mistake is not small. Sometimes that one form date error can cost a filing window, a CAP season, or months of time. The fourth major change is financial, and many workers and companies may feel it quickly. USCIS announced in January 2026 that premium processing fees would increase effective March 1, 2026. For H-1B employers, that matters because premium processing is often what gives them some control in an already stressful timeline. It helps with job start dates, travel planning, extension strategy, and project deadlines. But when fees rise, especially after years of rising filing costs across the system, that changes budgeting and sometimes changes whether employers will even choose premium processing at all. For workers waiting on an approval, that can mean more uncertainty and slower planning, even when the petition itself is solid. Now, let's move to adjustment of status, because this is where many green card applicants are getting hit by changes they do not always notice until it is too late. The fifth major change is the new Form I-485 edition dated March 13, 26. USCIS announced in April 2026 that starting June 1, 2026, it would accept only that edition, though it gave a short overlap period before then. Again, that may sound technical, but this is exactly how cases get rejected at the lockbox. When forms change, the agency expects applicants and attorneys to move with it. And when families are already wading through visa bulletin pressure, backlogs, and life planning, a form rejection can feel devastating because it is not just paper. It is time, money, and emotional damage. The sixth change is even more important for I-485 applicants because it affects what has to be filed with the adjustment package. When USCIS revised Form I-485 in December 2024, it said that if the applicant does not submit Form I-693 with Form I-485 when it is required, the Form I-485 may be rejected. That is a major shift in practical terms, because many applicants used to expect more flexibility on when the medical exam would be sent. USCIS also said the revised I-485 included updates to questions and to supporting forms. So now a clean I-485 filing is not just about the main form. It is about sending the right addition, the right supporting package, and the medical evidence in the right way when the case requires it. The seventh major change is about how long the medical exam itself stays usable. USCIS updated policy in June 2025 and said a Form I-693 is generally only valid for the period the immigration benefit application with which it was filed is pending. That matters because many applicants had become used to earlier assumptions that a medical exam might remain valid much longer in a broader way. But under the updated policy, if your case is denied, withdrawn, or otherwise no longer pending, that medical is not simply a forever document you can casually carry into the future. And when you combine that with the stricter filing expectation around submitting the I-693 with the I-485, it creates a new kind of pressure. People now need to time the medical exam more carefully and build their filing strategy around USCIS timing, not just doctor availability. The eighth change is broader, but it may shape green card and I-485 cases more than many viewers realize. USCIS said in March 2026 that it would continue strengthening screening and vetting procedures, and earlier announcements in late 2025 and December 2025 showed what that looks like in practice. USCIS created a new vetting center, updated photo reuse policy, so a previously collected photograph can only be reused if no more than 36 months have passed, and said these changes are meant to improve identity verification, prevent fraud, and protect national security. In plain language, that means more scrutiny. It means less room for stale identity records. It means applicants should expect the agency to look more closely at who is filing, what evidence is being used, and whether identity records are current and consistent. There is another layer here that people in family and employment green card lines should not ignore. USCIS continues to tie adjustment eligibility to the monthly visa availability framework, and the Department of State's current tools show that a lot of consular posts are still scheduling many categories based on documentarily complete dates that are far behind the present month. The State Department says interviews can only be scheduled if a visa is available. And it also says wait times are affected by staffing, local conditions, scheduling capacity, visa bulletin movement, and vetting timelines. So even if USCIS accepts your I-485, or even if your case is documentarily complete through the NVC, that does not mean the road ahead is clean or fast. This is why so many immigrants feel like the process keeps moving and stalling at the same time. There was also an important family-based adjustment update in 2025 that still matters in 2026 and beyond. USCIS updated its policy on CSPA age calculation and said it would apply the February 14, 2023 policy to adjustment applications pending before August 15, 2025. That matters deeply for children who are close to aging out because in some cases it can determine whether they remain eligible to adjust with the family or are pushed into a much harder immigration path. For many parents, this is not just a technical policy question. It is the difference between keeping the family together in one process or watching one child fall out of the case because time moved too slowly. And one more practical change that many people still miss is payment. USCIS now says it no longer accepts payments made by personal or business check, money order, or cashier's check for paper-filed forms unless the filer qualifies for an exemption. That affects mailed filings, and that means it affects many green card and I-485 applicants who still prepare paper packages. This may sound administrative, but once again, immigration cases are often lost in the small details. A wrong payment method can trigger rejection just like a wrong form addition can. So from 2026 forward, the safest cases are the ones built with the newest forms, current payment rules, updated medical rules, and a much more careful understanding of how USCIS is now reviewing identity and evidence. So when we step back and look at the bigger picture, the story is clear. USCIS is not just tweaking the immigration process, it is redesigning how the system behaves. H-1B is becoming more wage-wed and compliance-heavy. I-485 filings are becoming more rigid in form addition and medical submission requirements. Identity checks are becoming tighter. Payment methods are changing, and backlog pressure remains very real. That means from 2026 into the next few years, immigrants, employers, and families will need to be much more careful than before because the people who succeed in this system now will often be the ones who are not just eligible, but also prepared for a more technical, more expensive, and more heavily vetted USCIS process. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News Channel. Thank you for watching, and we'll see you in the next